If you are just joining us, I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. We are extremely honored that today, during our thought-provoking discussions of what has happened since 9/11, we have an address by a member of our administration who grapples daily with these issues, William Lietzau, who's the Deputy Assistant Secretary for Defense, for the Rule of Law, and Detainee Policy. Mr. Lietzau was appointed on February 16th, 2010, to a job that makes him responsible for developing policy recommendations and coordinating global policy guidance relating to individuals captured or detained by the Department of Defense. Prior to being at DOD, Mr. Lietzau was at the White House, where he served as the Deputy Legal Advisor to the National Security Council, where he addressed a variety of legal issues, including international criminal law, counterterrorism, non-proliferation, missile defense, foreign assistance, and treaty implementation. Don't they have more staff people at the White House? That seems like a very large portfolio. Mr. Lietzau has also served on several delegations for multilateral treaty negotiations and has taught international law at the Georgetown University Law Center's Master of Laws program. We are extremely pleased to have him here today. Bill?
Well, thank you for the invitation to come here, for that nice introduction and the opportunity to address you all. It's an honor to be here in this group. I will admit it's also a little bit intimidating. You know, when when you're the speaker at these things, you don't always get an invitation with everyone else because I'm not on the list. And in fact, I have people, fortunately, on my staff who had coordinated the timing. And I got an email just a couple days ago saying, somebody I met here who's in the audience, and they said, I'm going to see you. I see you're doing the keynote address at this function Thursday. I'm going to be there. We'll talk then. And I thought, I don't remember a keynote address somewhere Thursday. Hey, what's that all about? See, because when this was described to me, Alex Wagner, who's a special advisor in our office, and kind of one of the first generation founding members of this organization, he talked to me a while ago about doing a brown bag lunch with some of his law school buddies. And that's what I did remember. Oh, that's the thing. I'm the keynote speaker at a brown bag lunch. Interesting. And then when I walked in, of course, they gave me this thing to sign saying, we're going to film you and put it on the internet, and you're releasing this. Really? I've never been filmed at a brown bag lunch before. And last night when I asked Tara, so who's going to be at this thing? And she said, there's like 160 people signed up. We got members of the press from several organizations. And I realized, I've been in this job longer than any of the 6 people who've been the Deputy Assistant Secretary for Detainee Policy. It's perhaps my time. Seriously though, and it's reflective of the topic that I deal with. As I was walking out the door with this new information, I said, oh my goodness, hey, this is a little bit different than the brown bag I thought. And somebody, my deputy, said to me, don't say anything controversial. And I thought, I'm in charge of detainee policy for the Department of Defense. My very existence is controversial. There's no way to avoid it. And so what I guess all I can do, at this point, it's too late to prepare clever remarks that are very carefully worded so that I know what I'm saying. And that's not what I would want to do. What I hope I can turn this into is a back and forth conversation to talk about the things that are most interesting to you, because I guess what I can offer is my perspective on detainee policy over the last decade. As I did get to see the brochure last night, I said, let me see the invitation to this brown bag lunch. And then I see we're at the 10-year post 9/11. great timing, increasing the honor for me to be a participant in this thing. It also made me reflect. This morning I said, what do I say? And it did make me think back to 9/11. And so what I'm going to do is just share with you a little bit of my perspective on the detainee policy issue that spans this decade. In fact, what you didn't probably get in the introduction that Caroline gave was that I first got involved in these issues at 9/11. Everyone kind of remembers where they were in 9/11. For an earlier generation, it was where were you when John F. Kennedy was shot, and now it's where were you on 9/11. And for me, I was a commanding officer of a battalion in boot camp. I had 1st Recruit Training Battalion in San Diego, and we were training young Marines to go to war. And after 9/11, all the same kind of memories other people have. I remember the airplanes stopping, the quiet, all that kind of stuff, and everyone wanting to then, at that point in time, get into the fight in some way, somehow. And I was kind of uniquely situated because I had recently negotiated the list of war crimes for the International Criminal Court. I was the head of our delegation for that negotiation. And so I was asked to come back to the Pentagon because of 9/11 having happened. That was a lot of, in my own head, paradigm shifting. I'm moving from, I had been negotiating a treaty at the, by the way, just an aside, very different, because I still remember that moment as had just been negotiating a treaty at the UN. Now I'm in charge of a bunch of Marine Corps drill instructors, 2 very different means of persuasion from a lawyer's perspective, both applicable in post 9/11 world, very different. And I got to come back in January of 2002 to the Pentagon, and I worked for Jim Haynes in Secretary Rumsfeld's office as an active duty Marine, setting up military commissions and seeing the genesis of Guantanamo Bay, seeing the first discussions take place as to, are these prisoners of war? What are the different? What's the legal regime that's going to govern them? And in a way, depending on, I watched the fits and starts of the last decade, and how we got to where we are today. And, it's always clearer in hindsight than it is at the time. But in some ways, there's different metaphors for it. The most recent one I was using yesterday was a pendulum, as it seeks that balancing point, or a scale. You're always dealing with, and I think that's where we are today. We have a scale where we're dealing with the equipoise of when the military necessity, national security interests are correctly balanced against the various countervailing human rights interests that are in play, and that's the same kind of balancing that needed to take place in the very beginning. It's the same kind we need to do today. But we've come a long way in terms of getting that balance right. Whether it's a pendulum has swung back and forth and centered us, or that's what I'll talk about as my perspectives on it, because it wasn't that clear to everyone. It's not, though I would like you to believe that one of the first things I thought of, 9/11, I was watching TV, I was in the gym in the recruit depots on base. And I remember looking at the TV, seeing the World Trade Center crumble and thinking, detainee policy is going to be a mess in this conflict. No, of course I didn't. That was a joke. You were supposed to laugh. In fact, I didn't say that, and not a lot of people realized that detainee policy was going to be a mess. My job didn't exist. I said I'm the longest serving person in my job. We've never had anyone for even a year. I really am due to be fired. This is a very touchy area of U.S. foreign policy. It has been from the beginning. We created a Deputy Assistant Secretary of Defense for detainee policy because of the difficulties that have come about when we started detaining people. And you all And so what I won't do is go through the whole evolution of my own thinking in this area. As you know, my perspective has been to a large degree being on that pendulum. You don't always see that you're swinging in which direction when you're there. But kind of after the fact, having gotten off and now come back. And that's the end of the story, of course. Yes, I was working in Secretary Rumsfeld's office from 2002 to 2003, went back into my Marine Corps career, ended in the White House, and retired in order to take a job as a political appointee in the Obama administration. So I can't explain that either. But I'm glad to be here because I think I can't think of a more important issue from a foreign policy perspective. Let's face it. Why the heck did anyone invite me to speak at a 10 years after 9/11 event? Because detainee policy has been one of those most controversial things going on. Anytime you use the military instrument in securing your national interest, that is always going to have consequences that are less predictable than practically every other instrument. It's why we don't use it very often. And in this case, I would say, in the use of that instrument, it's the detainee policy world which has perhaps engendered the greatest amount of debate and criticism. As I was just visiting Al Jazeera headquarters in Qatar for unrelated reasons, and I walked through their museum, and there we have a former Gitmo detainee's clothing on display as one of their dozen or so exhibits. I thought, wow. The fact, someone's clothing from Guantanamo Bay is really worthy of a museum exhibit, which is kind of indicative of how problematic this has been. All that said, I think we're dealing with a very complex issue, and I don't want to, and I won't go through, or I would just completely run out of time, and I really want to, when does this end? In terms of figuring out how to do the, okay. So I really do want to be able to give you the chance to ask whatever questions you want about this topic. And the reason I like doing it is because I think it's so important that we better understand these issues. So I won't go through all of that thinking, but I would like to just briefly say where I think we are now and describe the problem and the solution that I think we're coming to, and why, frankly, I have some hope that we're at that place where we can get it right going into the future. It's the reason I took a job like this, because who would take a job like being in charge of detainee policy? Where I think we are, first of all, is the right paradigm, which has been something that especially the legal community has struggled with for the last decade, and that is war. In war, the ability to capture and detain is imperative for obvious reasons. One, the primary one is to deprive the enemy of fighters, but that's the obvious reason. But a corollary that I think is important to comprehend is it's also a more moral alternative to killing, which is the other way you deprive the enemy of fighters in war. Second purpose, third, depending how you number them, is to collect intelligence. In war, you want to be able to collect intelligence from those who are out to do you harm, especially in this conflict where human intelligence is so significant. It's what caused some of the problems that were so controversial in recent years. So nothing I've just said would have been controversial to say in 2000 or the beginning part of 2001. In fact, detaining people in armed conflict has not been controversial for centuries. That's what armies do. That's what they've done for centuries in war. The problem is, my second point, I guess, in this syllogism of describing why we have this problem and where I think the solution is that this war is different. It's a different kind of war. First of all, our enemy is not a state. The legal framework then associated with this conflict is a little bit different than the ones in past conflicts. Certainly different than, we're all familiar with the Geneva Conventions of 1949. What were they written after? Written after World War II. They're designed to prevent particular abuses that flowed out of World War II. This is not like World War II. We don't even have a state as the enemy. We're fighting against a transnational armed group that has global reach. But even in that regard, it's not even like a traditional non-international armed conflict, which was envisaged in 1949, even if it wasn't particularly well regulated, because there was an agreement among states as to how to deal with non-international armed conflicts. Even if we had come up with a clear level of agreement among countries in 1949 on non-international armed conflict, we wouldn't have been thinking of this scenario. In fact, we now call it a non-international armed conflict because we had a Supreme Court case that took us there in the Hamden decision. But if you were to look at it in 2001, 2002, and you actually look at the language of the Geneva Conventions, it's not non-international armed conflict. It's conflict between states parties to the Geneva Conventions. Nope. And then it also discusses conflicts not of an international character. Well, we have 40-odd countries in an alliance with us over in Afghanistan right now, fighting someone who, made their way all the way from Afghanistan halfway around the world to the World Trade Center. Is that not of an international character? I don't think that was very clear in 2001 and 2. Okay, so one reason this war is different is because it's not against the state. A second reason it's different is because the fighters are not lawful combatants. And most of the provisions that are applicable, especially in the detainee world, are oriented around lawful combatants, an assumption that they're lawful combatants. That's what the Third Geneva Convention is about. It's the Prisoner of War Convention, and Article 4 describes who gets the protections of the Prisoner of War Convention, and it's not that clear. Well, I take that back. It is clear. The Third Geneva Convention is fairly clear what you do with prisoners of war, but it's prisoners of war that fit the paradigm that the conventions were written for. And the third way, perhaps the most important at this point in time that I think this war is different, is its ending is not easily discernible. And the things that I'm just saying seem very simple. You'd be asking, we said this was so complex. Why have we not been able to get this nailed down and get it right for the last 10 years? I think at its core, it is simple. I think, I'll take you to the third step, which shows how simple it is. In war, you need to be able to detain. This war is a little bit different. The legal and policy framework weren't really designed for this war. So we have to figure out what adjustments are appropriate to that legal and policy framework to make it make sense for this war, consistent with our American sensibilities and the human rights interests that are prevailing here. It's simple, but then there's all kinds of things that have hit us along the way that have caused complexity, and there's, of course, the political dynamic. As sometimes these problems are looked at there's a tendency in our politics. Let's face it, we're a two-party system. Not only that, we tend to look at problems binary. You're either, we started off with you're with us or against us. The Soviet Union was our friend in World War II. Not so much afterwards. There's a tendency of you identify good and everything else is evil, or vice versa, and that binary way of looking at things has also complicated the way we address detainee policy. And so I'll get to the final point. When we then look at, and I'm just doing that because I wanted to give half the time to be able to ask questions and go back and forth, because I think there are so many related issues here that do complicate it, but at its core, getting through the simple part. If you're in war and you've got problems with this legal framework, what are those problems and how do we address them? First of all, some of the ones that weren't that unclear, we've already taken care of. You could summarize it, for instance, in the look to some of the president's first speeches in office. Look at the archive speech in May of 2009. We have taken care of. We've made it absolutely clear our interrogation practices are consistent with the rule of law as we know it, and our principles. And that's across the board for all departments in the U.S. government. We also, when appropriate, the president laid out that we would try people in criminal courts. If possible, if it made sense, Article 3 courts were what was listed as a preference in that archive speech. We also made changes to the military commissions to bring them more in line with what we believe to be our values. And in those cases where we ended up with people still at war with us, we have long-term law of war detention. I say long-term because that's the difficulty. If I really were to take where in all the pressures against international law that the ascendance of terrorism has wrought, I would say the primary one that has been the difficulty in working our detainee policy is the absence of an appropriate process for the individuals. If you look at the problems I described in the war, you've got a problem of it's not a state. We don't have states' armed forces. In the United States at the end of World War II, we had over 400,000 prisoners of war. Not really that controversial. There were a handful of cases. There actually was a habeas case. Some people say, oh, there's no habeas in World War II. There was 1 or 2 cases. But there wasn't cases for 400,000 people in uniform that they didn't even ask for a lawyer. We certainly didn't give them a lawyer. We certainly didn't give them access to courts. We're fighting a war. You knew who the enemy was. And you knew, and they were, for the most part, lawful combatants. We weren't thinking about prosecuting them. They haven't necessarily committed a crime. In war, you kill the enemy, and we were their enemy. So we didn't go and start prosecuting Nazi soldiers for having attacked us in war. At the end of the war, we took the 400,000 soldiers and we said, hey, war's over. It's time for you to go back to your farms. And so, sorry you guys lost, but you can go home now. And we're not worried about 399,750. I don't know if I just did the math right. But we weren't worried about most of them, any post-conflict concerns, except for a handful that had committed war crimes. Not you guys. You guys were going to hold a little bit longer. We're going to prosecute you and punish you for something you did during this conflict. The rest of you, we were only holding you because you're a threat to us if we put you back on the battlefield while we're at war. You're no longer a threat to us if you're no longer at war. The war is over. So we knew who we had. They weren't criminals for the most part, and we knew that we were only going to hold them till the end of hostilities, and we could identify when the hostilities were going to end. We might not have known it was the USS Missouri that was going to be the signing place of a surrender agreement, but we knew there was going to be some kind of an agreement that would mark the end of that conflict. You could have a whole panel discussion about when the end of the conflict is right now, and those are the difficult issues we still have to grapple with. But with those issues, with that being the legal and practical landscape that we live in right now, what we don't have in the law of war as written is a process to determine, do we have the right guy? Are we lawfully holding that right guy? And is his threat substantial enough that we need to continue holding him, or there's not some other way to mitigate that threat? Now the problem is, if you look back 2002, I often use a chart to describe, this fairly simple yet often misunderstood paradigm shift. Alex would not have wanted me to use that chart in this brown bag because there would be no place to put it where everyone could see it. But in fact, what I do is I have the law of war going down one side of the chart and the law of peace going down the other side. You know, in the law of peace, you have human rights law on the international side, and then it dips down into domestic law and puts criminal procedure. On the law of war side, you have jus in bello, the law applicable in war, essentially the Geneva Conventions, Hague regulations, for lack of in summary. And then the domestic implementation, we don't have too much. But you didn't really need too much because the rule is fairly simple. Your legal authority to detain is simply, you can detain them till the end of hostilities. Same legal authority that is there for a non-international armed conflict. Not a lot of domestic implementing legislation, not a lot of international legislation with respect to this new type of conflict I was mentioning. So when lawyers first looked at this in 2002, what paradigm did they go to? They went to the one where every single person who's been to law school in the United States, the course that they've taken, which is criminal procedure. And that's the paradigm we're familiar with. The government needs to jump through some hoops to take away someone's liberty. He's a free man walking the streets. You want to take away that person's liberty? You're familiar with all the rights. You know, you're going to have probable cause. You're going to have an arrest that's got to have lawful requirements. You're going to have your Miranda rights read to you. You're going to get a lawyer. You're going to have to be proven guilty beyond a reasonable doubt and everything else. That has never been the paradigm that would apply in war. For the reasons I just stated, you couldn't do that. You wouldn't want to do that because remember, we're detaining someone in war because of their future threat, not because of a past bad act that they need to be punished for. And that's a major, that has been a major, though simple, problem in the last 10 years of getting understanding that takes us to the place where we have that balance. And then coming to that place, we go back to then the process point I made. Well, wait a minute. Okay, fine. We understand it's the law of war side that we're dealing with. The law we have developed in this country in the last 70 years since the Geneva Conventions were written weren't really oriented toward these prisoners of war, these people that you're holding in an armed conflict. So, so what are you going to do about them? You just hold them till the end of hostilities, and now you've got, because when's the end of hostilities? You just described these problems. You're not quite sure who you've got, as well as it's not as easy to discern as in the prior conflicts, and you're not sure when this conflict will end. And I would argue that when you look at those issues, what we need, what we're familiar with in this country, is a process by which we can make those decisions. And we're going to have to do it on a more individualized basis than you would do it in other conflicts where you have a state-on-state conflict. And if you look at how our policies have been evolving over the last decade, and especially in the last couple of years, you can see that that's exactly what we've been doing. We have been identifying processes that make sense as we've been living this experience. For instance, in Afghanistan right now, if you are captured on the battlefield by U.S. troops, you'll be screened, determine if you're going to continue to be held. Are you still a threat into the future in an initial assessment? If yes, then you go to our detention facility in Parwan. And at that facility, we've established a process where a board of 3 field grade officers, senior officers, will review all of the evidence, all of the information that's collected about you, about that detainee, and the detainee will have a representative working in his best interests in order to assist him in presenting whatever kind of case can be made, as the right to call witnesses directly, by telephone, by video conference, take affidavits, and there's a hearing within 60 days to determine, 1, do we have legal authority to hold this person? Is it appropriate to hold him under the law of war? And 2, is his threat significant enough that we want to keep holding him under the law of war? That there's no other way to mitigate the threat. Because anyone who thinks that the Department of Defense wants to detain people you just don't get it. There's no way a commander on the battlefield wants to have to worry about a bunch of detainees while fighting war. So if you can possibly find another alternative to law of war detention, you're going to do that. And that's partly what that board does. So from a detainee's perspective, it's seeing it as a legal authority. From a commander's perspective, it's saying, do we really have to do this? And then there's a periodic review thereafter, where the question gets revisited. Now, we have a different group of detainees in Guantanamo, for example. And then I leave off Iraq, because in Iraq we have shifted. We're, the denouement of that conflict, and we're past the point where we're in, active combat operations. Hopefully we're bringing Iraq with the Iraqi government into a peacetime society where law enforcement's the paradigm. You're no longer in the war-type paradigm. And in that regard, we've transferred cases over to the Iraqi criminal justice system. Now in Guantanamo Bay, the third area, we have a group of people who've not just captured, many of them there 8 years, have already, because of the fits and starts I described as the United States grappled with this detention problem, they've already had habeas rights. They are already represented by counsel. They've been able to get into U.S. District Court and have a judge determine whether or not they're lawfully held. But that doesn't change that second half of the equation. Because believe me, as the guy that deals with Guantanamo Bay, not my interest to have people there if we don't have to. So as the president announced earlier this year, we have an executive order creating a periodic review board that will involve an interagency process of senior officials from various departments in the government to, again, look at the same question. Is the threat significant enough that we need to continue holding them? And providing process where there's actually a right to counsel. There's so there's complete representation, a right to counsel, and access to a much greater wealth of information that can be looked at to decide if, in fact, under the law of war, it makes sense to keep detaining them. Coming up with these processes, I believe this is what gives me hope, because when you look at this pendulum, if you will, just using that as the paradigm, at one end, you have those who are most critical of Guantanamo right in the beginning, and they're coming from their sensibilities informed by our own legal system. They say, what the heck? The United States does not hold people without trial. Either prosecute them for their crimes or let them go. That's the American way. Well, you need an adjustment. We've got, this is war. You can't tell an 18-year-old soldier who in war has authority to kill another human being, oh, you may end up killing another human being, but if you capture him, remember, you have to have enough evidence to prove him guilty beyond a reasonable doubt in a criminal trial. That is not a place any of us should want to go. And so when you then make that adjustment and you just say, okay, well, now we apply the law of war, you can hold them to the end of hostilities. No, we need process. And that's why I think what our American sensibilities were really offended by was not so much that it wasn't a criminal case. Our gut was telling us you need process. There's a due process associated with taking away somebody's liberty. The process wasn't as necessary in a situation like World War II. It is in this unique kind of conflict. And if I were to describe where we have come in the last decade in dealing with the detainee issues, it's coming to the realizations of where are the weaknesses in the legal and policy framework? How is this war exactly different? And how do we adjust, consistent with our values, a process that resolves this issue and allows us to go forward in 21st century warfare against this kind of a threat in a way that we can say is consistent with our values as Americans? That's where I think we are now. That's why I'm hopeful for the future of detainee policy, and I'm hoping to write myself out of a job in that regard. And that's why we've added kind of rule of law to the beginning of the title, because then we can branch off into more general areas that aren't trying to correct misperceptions of the past. So, making this up as I go, I guess I'll end there and see if you have any questions. Yes, sir.
Yes, I personally.
Sorry, can you wait for the mic? Just wait for the microphone and please identify yourself before you ask.
Yes, my name is Stephen Spitz, and I personally heard President Obama, when he was campaigning, one of his central promises that if he was elected president, Guantanamo would be closed. And I'm wondering what you can tell us about the status of that.
I was on active duty during the campaign, so I hadn't heard that. Well, I think that and one of the difficulties is the whole paradigm I just described, interestingly, I guess now that I think back on it, doesn't even really touch on Guantanamo. The problem is Guantanamo has become such a symbol to the world. What you have is a set of allies, an international audience, if you will, and a domestic audience who has come to see Guantanamo as a symbol of what they see as offensive against American values. That's unfortunate, because I think the real issue that we have to come to grips with that goes beyond the politics is law of war detention in the 21st century. That's the real issue. That said, we nevertheless have to what we have to do is address the problems where we are right now. And I think the administration has made clear that it is still absolutely in favor of closing Guantanamo. There are obvious for somebody, if you spend much time with our European allies, the idea of closing Guantanamo, it's not difficult to figure out why that benefits our foreign policy interests. It unfortunately is seen in a very negative light. Many of the things, even like standard war crime abuses that happen in war, not related to any policies or misunderstandings I was just discussing, the Abu Ghraib-like incidents, those kinds of things all get wrapped into the term Guantanamo Bay by our allies. And so I think for those reasons alone, there's clearly a benefit to closing Guantanamo. Also, but all that said, I would hate to lose the real focus, because when I think the history books, when they look back at what did the Americans do in 2011 to address this issue, what did we do as the law of war was evolving to accommodate a new type of conflict, I don't think the geography of where they are is going to be the primary issue. I think it's going to be coming to this recognition of where the balance is. So I think there would be foreign policy benefits to closing Guantanamo Bay, and that's why we favor it. You're familiar with the politics domestically that impede that significantly, and that's unfortunate. Those are the complicating factors I have to deal with, and those are also likely the reasons I get fired for saying things in public like this, because of those complicating factors that have nothing to do with the essence of the legal issues in play. I didn't really mean I'm expecting to get fired, by the way, so nobody should write that. Yes, ma'am.
In the process that's being envisioned, how does someone who's been detained for 8 years prove that they're no longer a threat? All they have to prove is passage of time. Is it going to be outside factors that they have no access to prove? By the way, my name is Mary McCormick. I forgot to identify myself. But I'm trying to envision how a detainee with a lawyer goes about proving that they should be released.
Yeah, that's a great question. It's I don't know if I'm qualified to provide the tactics to the council we'll be representing, but actually, see, we have, in fact, it's not so much that he has to prove that, because remember what I said earlier, and I mean it, the U.S. government has no interest in detaining someone longer than they have to. It's not like this guy had a constitutional right to be represented, and that's why we've set up the system. We set up the system because we want him to be able to make the best case he possibly can. We want to get this right. So we're going to be looking at all of the intelligence collected on each individual, assessing something that made someone detainable at one point in time might not make them detainable later on. Even during the war in World War II, we paroled many prisoners of war who were agreeing not to rejoin the fight. What's taking place is an assessment of, is this guy still at war with the United States, and is his threat to us substantial enough that we have to hold him where he is, understanding the foreign policy implications that right now he's in Guantanamo, making it even worse for the reasons I just mentioned. But with that counterbalancing harm to our foreign policy interests, that's the assessment we're making. So I can't say what they will do. They will have access to an attorney to make a case that it might not have been made previously. They'll have access to all the information that gets used to suggest that the person is, in fact, a significant threat, and copious amounts of information that have not been available before, haven't been collected for both sides together. Because remember, that's one of the lessons we learned early after 9/11. We have, Department of Homeland Security, if you remember, didn't even exist right after 9/11. We have really improved those processes of synthesizing the different intelligence sources to get them all together in a place that's usable for both sides, and they'll be available for both sides in these hearings. Sir.
My name is Jim Flug. This may be slightly off topic, but I think relevant, especially in an audience of lawyers. For the past few years, I've been teaching a lot about the role of the government lawyers, and especially the Defense Department lawyers, in the development of the torture policy and the vetting of the torture memo. It sounds as though you were in the General Counsel's office at that time. Can you give your perspective of how the lawyers up and down the line performed in that issue of developing the law of war?
No. No. Of course I can, though I have to say that particular issue was not something I was working on, so I can't really strike at the heart of that particular issue. I can say that up and down the line, as is the case now, what you had as a general rule, you have lawyers, well-meaning lawyers with the United States government as their client, trying to come up with the right answers to difficult legal issues. Now, whether that would apply to the specific legal analysis that I guess is the most controversial that you dealt with, I'm probably not the best person to answer that, but I can just answer in a general way. We're struggling with military commissions. Should there be a civilian defense counsel or not? What should be the list of crimes? Is there going to be status-based offenses? Are they going to be classic law of war offenses? Should crimes against humanity be included? What should the processes be? What is the detention authority? If you remember the president's first military order, it wasn't really about military commissions as people remembered. It was also about detention authority of DOD. There was I want to say confusion, but remember the president's first speech, President Bush, right after 9/11. The two paradigms I described, they were mixed right then. This is an act of war. We're going to bring them to justice. Two different paradigms being discussed the whole time. We're going to bring them to justice sounds in criminal procedure, sounds in human rights law. International Covenant on Civil and Political Rights would be the body of law our international allies might look to. This is an act of war. Sounds in the lex specialis of jus in bello. It sounds in and the inherent authority to detain. Often not even seen then, because there's a fourth. I mentioned three complicating factors of the war. There's a fourth, actually, besides being unprivileged belligerents, unlawful combatants, whatever you want to call them. Most of the enemy we fight were traditionally thought of as criminals. Terrorists we dealt with a criminal paradigm for years prior to 9/11. So being criminals as well, that was already in place. We already had, we had in international law, we were developing the Terrorist Bombing Convention, one of the first treaties I worked on, the Terrorist Financing Convention, Nuclear Terrorism Convention. These are the extradite or prosecute regime. So all these legal issues were being dealt with. And then naturally, one of them was the what are the limits on interrogation practices. I wasn't there for it, but I can say the lawyers that I saw, military and civilian, were just trying to get it right. There's something. Almost every time I speak in these subjects, I end up quoting Oliver Wendell Holmes. My own staff is sick of hearing me say it, but it's a quote that it's the only thing I really learned in law school, because it was engraved in stone, and I had to walk through that passageway to get to my car. And it's a quote that says, "The life of the law has not been logic but experience." And I really think if I were to both explain why it has taken us 10 years to get to this place and explain why it's perhaps a good thing it has taken us 10 years to get to this place, it's embodied in what I think Holmes meant in that quote. At first I used to be bothered by it, that it suggested that bad facts are going to keep making bad law, something every law student hears. I really think now in hindsight, no, what he was talking about is you're not smart enough to make the law the way you think it ought to be at the point in time when you're making it, if you're trying to make it prospectively for the future. You need experience. Alexander Bickel had another similar paradoxical line he used to use, I guess, is when essentially when writing law, remember the future and imagine the past. And he always says, oh no, he must have miswritten that. He's got it backwards. No, but I think what he's saying is the key is people are going to be looking back at what you were doing at the time you passed that law and the circumstances that were in play then. But you have to remember that there's a future where they're going to be looking at what you were doing when you were writing the law. And I think that, yes, if you'd asked me in 2002, do you have an answer to all this, and would you like to be in charge of the world and share it? I probably would have done it, and I would have gotten it wrong. And I think that's been the case for our country in a lot of ways. We needed to live through some of these things before we could really understand the problem well enough to solve it. Anything else? Is that a good place to... Sir.
Thanks. Hi, Martin Hindle. I'm wrapping up 3 years and change at the Office of Military Commissions. Today's actually my last day. And thank you for your comments. I've appreciated them. There's a question I've had throughout my whole time at the office I've served in, which is reawakened by some of your comments today, and I'd like to just try to state it for you and ask for your feedback on it. And that is, at the risk of being potentially asking a dumb question, I've wondered all along, why are we at war? In other words, why did we characterize what happened on 9/11 as an act of war? And if you'll just permit me for a minute, sir, after the 1993 bombing of the Trade Center, we did not consider that an act of war, nor did we after the Tanzanian bombings. In 1996, when Osama bin Laden declared war on the United States, we did not consider ourselves to be at war with al-Qaeda or with any other affiliated entities. In 2000, when the Cole was bombed in Yemen, killing 17 sailors and doing billions of dollars of damage, we did not consider ourselves at war. We have a whole mechanism that has existed for decades to handle terrorism offenses and has done so with tremendous success, hundreds and hundreds of cases in the last decade alone. And if we could just for a minute call war a duck, you in your introductory comments very eloquently explained why what we've been doing the last 10 years doesn't sound like a duck, doesn't look like a duck, doesn't quack like a duck. And yet our leaders have insisted on saying to us, this is a duck, trust us, it's just a duck we haven't seen before. And so I'm asking you, why are we at war? And why have we gone to the left side of your diagram that, in my view, has really triggered all of the thorny problems that you've accurately identified of when is it over? Can we hold on to these people at Guantanamo after they've served their terms, or even if they're acquitted? Can we hold on to them in the name of war? Can we operate with the twin aims of interrogating them and collecting law enforcement? Can our law enforcement officials talk to our intelligence gathering officials in ways that they were not allowed to before 9/11? And why have we taken on these incredible burdens and created this mess for ourselves to produce a hybrid system that has accomplished neither of the benefits of the civilian or military legal justice systems? It's not as good as any federal system. None of the protective rules are as robust. And it's not as good as the military system, and it's a blight on our image on the national stage. I mean, sir, we have people like Robert Mugabe citing us with approval.
So,
My
no, I
question-
think
and
I got the
is-
question.
and pardon me for getting a little emotional here, but my question
So you do have
after
opinions
doing
on
this
this.
for 3 years, I'm really wondering, why did we decide to do that in a way that's made everything more difficult for us and made us less safe and reduced our reputation? We've thrown away all of the best things of our national values. Thank you.
Well, that was a dumb question. No, not really. I think there's really two answers. One, remember that decision was made at a different time. And everyone, and at that point in time, I think it was clearly the right decision. Now we have the ability to look at it in hindsight, and I would say it was clearly the right decision. First of all, it's not the way you describe it. We're calling it a war. I often hear that in legal circles right now when those law of war experts are and various international law experts are grappling with, what is the pressures on international law in the 21st century. They often grapple with what is war and what isn't war, as if it's some existential thing that we can describe from a distance. States decide when to go to war. If your leaders told you we're at war. Now, you may disagree with the legality of that war. You may say, hey, under the UN Charter, that was a violation of the law, or under jus ad bellum, you were wrong to go to war. But you can't really say you're not at war. That's not any of our choices. It never has been in history. But why would you go to war? So there are significant foreign policy implications of going to war, but you do it when you have to do it. And at the time, at 9/11, remember, just to take you back, what was the world's view on whether we would be at war? You described, I think correctly, the way we had been addressing terrorism for years, primarily as a criminal construct, not totally. A couple Tomahawk missiles into Afghanistan during the Clinton administration, into Sudan. We're all familiar with that. Oops, but then we went and prosecuted those who we could capture. We captured, I think we got 4 prosecutions out of the East Africa bombings. I don't know how many casualties we had in the military action that preceded that. But we primarily were dealing with terrorism as a law enforcement matter. I think what happened in 9/11 is there was a realization that this isn't working. Dealing with this as nobody after 9/11 was saying, hey, the law enforcement paradigm's been working pretty well with this terrorism stuff. Yeah, we know Osama bin Laden declared war on the United States in 1998. Are we going to tell him, oh, you're not really at war either? Some outside source tells you when you're at war, Osama bin Laden, and you're not at war. If Osama bin Laden declares war and he thinks he's at war, he's at war. And if we say we're going to be at war, we're at war. And then the question is, was it the right thing to do? What happened the day after 9/11? We have a Security Council resolution recognizing the United States' authority to act in self-defense, consistent with Article 51 of the UN Charter. Who drafted that resolution? Does anyone know? It was the ambassador to the United Nations from France. How many voted against that resolution? 0. How many statements were made in the UN General Assembly criticizing the United States' use of force in war with our military forces on the ground in Afghanistan in October when we went there? I tell you, since the UN Charter was signed, every time the United States has used force, there was significant criticism of whether that was an appropriate use of force or whether it violated the UN Charter as a whatever the question was, self-defense or the justification. Not too many hands up in the air within the General Assembly post 9/11. NATO, Article 5 resolution, saying an attack against one is an attack against all. SATO, same kind of resolutions. Organization of American States, consistency across the international community that we are at war. We're all expecting the United States to go to war. You shouldn't have knocked down their World Trade Center and put a hole in the Pentagon. Bad idea. And the way we have been dealing with this in the past hasn't worked. Now we look at what it has taken to take Al-Qaeda to where it is now. You've seen pieces of it in the news all the time. All I can say, and right now I've got 171 detainees in Guantanamo, but that is, we've captured far more people in this conflict, and we needed to capture far more people to get to the place we are now, to undermine the warfighting capability of our adversary. And what if we had used the criminal justice paradigm from day one? Well, let's see. Within 3 days, you got to get in front of a magistrate. You got to make a probable cause case in front of that magistrate. Maybe under some systems you could take it up to a week, but that's as best you're going to get. Then you're going to get a bail hearing. Then you're going to, give them a right to a lawyer. And we've got battlefield commanders pulling these guys out of caves in Afghanistan. How in the world are you going to make that criminal justice paradigm work as a way of detaining people in war? Not to mention the fact that usually you don't have authority to shoot someone in war. I'm sorry, you do in war. And you don't in the law enforcement paradigm. We would have had all I can say, and I should stop here because a lot of things are classified and I can't get into those, but I think it's fairly widely accepted that to the extent we have had successes in an armed conflict against a transnational terrorist organization, we would not have had those same successes had we used a law enforcement tool. Would it have made it easier to deal with some of the foreign policy issues? Yes. And could we have avoided the detention component that I think is one of the most difficult pieces of this war? Yes. But we also want to win the war. And in that's a different balance than the one I was talking about with detention, but I think it's a balance that we made right. I know I've gone over time here, and I appreciate your listening, but I forgot to give my you try to think, what things do you say, especially when you are too lazy to make notes. And the one that is on our coin that we just got, that our goal in our office is to create a principled, credible, sustainable detention policy. Okay, so I'm giving you that one-liner right now because I think that's the important thing that we need to do. The due process piece I talked about that I think is the biggest missing piece, that we're addressing, that's the hard one. But what you can't have impeding that is any other problems, Abu Ghraib-like problems and everything else. Our detention practices need to be so above board that we're back to where we always were, as the unquestionable leader in the international community in the rule of law. That's why when we look at our practices, we have to get those practices right, and then where the law and the policy framework isn't exactly laid out, we have to figure out what it should be in a way that fits our sensibilities. So thank you very much. Appreciate the time.